You're watching UPfront on the Joy News channel. So many would have thought that the decision by the Supreme Court to quash a High Court's decision earlier in Tamale on the possible rerun of the elections, parliamentary elections in the Kpandai constituency of the Oti region, would have brought matters to a halt. But it is emerging now that the National Democratic Congress's candidate in that constituency is not giving up. In fact, he plans to return to the Supreme Court asking for a review and, of course, asking the court to enforce the will of the people. That's the latest we're receiving on this matter, bringing up the whole spectacle about by-elections that we're just reeling from, the latest being the one in the Ayawaso East constituency. We'll talk about that in a bit, but here's the latest on the Kpandai situation for you. You have that on your screens, pointing out to why lawyers believe that an earlier ruling given by the Supreme Court ought to be reviewed. And the lawyers for Mr. Wapai, who is the NDC's candidate in the Oti region's constituency of Kpandai, they believe that the earlier decision of the High Court ought to be upheld. The fact that there ought to be a rerun, a by-election in the Kpandai constituency, because the ruling by the Supreme Court granting what the current or incumbent MP Matthew Nyindam went to court for, asking the decision of the High Court to be quashed, will not lead to the delivery of justice for the people of Kpandai. In fact, the new basis for which we're having all of these claims being raised by lawyers for this NDC candidate is that, first of all, they are relying on Article 99(1) of the Constitution, and that the fact that the Supreme Court, according to their view, did not take a look at issues from the perspective of Article 99(2) of the 1992 Constitution. The argument being made now is that if you're aggrieved by a determination of the High Court regarding matters specifically relating to the outcome of a parliamentary election, then you must appeal to the Court of Appeal. So that's a new twist to the matters for which the NDC candidate, through his lawyers, is now asking the Supreme Court to consider a review of the matters that may possibly lead to a situation of a by-election if indeed the Supreme Court departs from this earlier decision they gave, quashing the decision of the Tamale High Court. Quite a controversial matter coming up again, just on the back of a by-election that's just ending in the Ayawaso East constituency. So how does the NPP view this? The fact that their numbers in Parliament may further dwindle. That's the concern emerging. Okay, I'll tell you about my guest joining us to do this. First, though, online is the legal spokesperson of the Minority Caucus in Parliament, lawyer John Dako, who's MP also for Swami. And then we have Wanda Victor Kuto, who is a member of the National Executive Committee of the National Democratic Congress and also a board member of the Volta River Authority. I'll get back to him in studio shortly. But first, let me start off with you, Counsel. Is this a surprise to you? Because many were thinking that once you have the Supreme Court make a decision or a determination on this matter, that would have been the end of it, except to say that they're free to depart from their earlier ruling. So the NDC candidate is still challenging that. Surprise to you in the first place?
Well, thank you very much. But I mean, it's surprising because looking at the judgment that was delivered by the Supreme Court and the argument being made by the lawyers for the NDC, I'm shocked. But look, it's their right. They are entitled to do this, and I believe that the court will look at it critically. But I mean, as lawyers or as officers of the court, when we are discussing these issues, ours is just to put out the legal opinion and leave the decision or the judgment to the Supreme Court. But look, I can say that any serious lawyer looking at the argument being advanced by our brothers in the NDC will tell you that this case will go nowhere. Look, what is the issue? I think that you laid out the foundation very well. Article 99(2) that they are talking about really talks about a determination, a decision of the court. When you are challenging the propriety of the decision of the court, That is what you do. You appeal to the Court of Appeal. In fact, the first lawyers of Martin Dam did that. But upon review of the judgment by Gary Marfo, he came to the determination that the court completely got it wrong and that the court did not even have jurisdiction in the first place to entertain the matter. So when we went to the Supreme Court, invoking the supervisory jurisdiction of the court to quash the whole judgment and the processes before the court. The decision at the Supreme Court was not about the determination of the case by the High Court judge who sat in Tamale. It was about the fact that the court did not have jurisdiction to entertain the matter. And lawyers will tell you that you cannot build something on nothing. It will not stand. Because of that fundamental error that was occasioned by the judge, by wrongly assuming jurisdiction, the court said that the judgment and all, in fact, the writs and the judgment and all others were supposed to be quashed and be declared as null and valid, as if nothing had happened at all.
I'm glad
there's
that
nothing to really appeal against.
Yeah, I'm glad that you're raising this principle of jurisdiction now, because that's the new twist to issues. What's your interpretation of 99(2) of the Constitution? That will also bring up the same principle you're talking about, isn't it? Procedurally, the NPP lawyers, by extension your team, has not made use of what the procedures are, that you may have to resort to the Court of Appeal and not the Supreme Court in the first place.
I made that point. You will notice that when this matter was, the first thing we did was to file the appeal at the Court of Appeal and then ask for stay of execution. That was the first thing we did. And then upon review of the document, we realized that the court did not even have the jurisdiction to hear the matter in the first place. And that is why the new lawyers filed this process before the Supreme Court, invoking its supervisory jurisdiction to quash the decision and the processes at the High Court. And so my brothers in the NDC have a complete misapprehension of Article 99(2). 99(2) is dealing with a decision or a determination of the High Court. When the High Court makes a decision and you want to challenge the propriety of that decision, you go to Court of Appeal. What we did at the Supreme Court was not to challenge the propriety of the decision of the High Court. What we did was to challenge the assumption of jurisdiction by the court, which was wrongly assumed. And so if you wrongly assume jurisdiction in law, because you don't have jurisdiction, you cannot even hear the matter. And so there was nothing before the court for the court to even determine, because the court did not have jurisdiction at all. And that is why the Supreme Court, 4-1, agreed with us. In fact, this is not the first time this position is being canvassed. The first time this Article 99(2) position was canvassed was by the dissenting judge during the hearing of the matter. The dissenting judge raised the issue and asked the NPP, Gary Marfo and his team, that don't you think that your remedy lies in Article 99(2) and that you should go to a Court of Appeal instead of coming to the Supreme Court? And Gary said, no, we are not challenging the determination of the judge in Tamale. If it was the judge's determination we are challenging, our remedy will lie in the Court of Appeal. And look, all the other 4 judges listened to this argument that was made by the dissenting judge, his Lordship, Justice Praman, and they all disagreed and said that, look, what the court had done, what the High Court Tamale had done, was to violate the Act 284, that having filed the petition after 21 days, the court did not have jurisdiction. You understand?
Because but okay. Do you acknowledge?
Let me make this last point.
Yes, right.
The Supreme Court in the Akotia by-election had made a decision that it is the 24th December Gazette notification which is valid, and not the 6th General Gazette notification. So also on that basis, when you file a petition on 25th January, that is clearly over 30 days after the publication of the Gazette. And so on that basis, the Supreme Court said the High Court did not have jurisdiction to entertain the matter. So when we came to the Supreme Court, it was not about a determination of the High Court that was being challenged. It was about the fact that the High Court did not have jurisdiction. And that is why we invoked the supervisory jurisdiction of the Supreme Court.
Okay.
And by 4-1
I've got a question for you. Do you acknowledge the ruling of the High Court in the first place as a political party?
Okay, so that decision, in our view, doesn't exist because of the decision of the Supreme Court. The decision of the Supreme Court.
Yeah, but that's not the basis of my question. My question to you is: Do you acknowledge the ruling of the High Court?
Okay, so let me answer it this way. In the first place, the ruling of the High Court was being challenged by the NPP at the Court of Appeal. We believe that it was a very wrong decision. That is one side. But we also believe that even though the decision itself could be attacked, we had to go to the root because the court did not even have the jurisdiction, one, to hear the matter and to give that impugned decision in the first place. So there are two things. You can attack the decision or you can attack the assumption of jurisdiction by the court. So, in law, jurisdiction is very, very key, very important. In fact, if jurisdiction is not granted to you and you assume it, anything you do subsequent to the assumption of that wrongful assumption of jurisdiction will be quashed. And that is what the Supreme Court did. So even though the NPP did not believe or did not accept the decision of the court, our attention at the Supreme Court was not to attack the decision. Our attention at the Supreme Court, our main job at the Supreme Court, was to say that the court did not even have jurisdiction to give that impugned judgment. And so let's attack it from the root. And that's what we did. And that is what 4 out of the 5 Supreme Court judges agreed with us.
Well, you're both lawyers, so it's a good time to bring in lawyer Wanda Victor Kuto. Thank you for joining us too. Yeah. You've listened to lawyer John Dako on these emerging matters. First of all, I mean, why the desire to clinch onto more seats as the National Democratic Congress? Is it the case that you're hungry for more parliamentary seats? Because I mean, you have quite a number of seats in Parliament.
Thank you very much. Good evening to you, the Senior Council on Zoom, and then to our viewers. Yeah. I mean, clearly, none of the MPs in Parliament will be able to push the agenda of the NDC in Kpandai rather than the NDC PC. So it's natural for persons within the party in Kpandai to want to have a member of Parliament representing them who is an NDC activist. I mean, it's natural. But talking about the legal issues, I agree largely with the MP for Swami, largely, because the matter that was before the Supreme Court, it's not a petition. It's a certiorari application. That was what was before the Supreme Court. It's not the substance, it was the procedure. Because the MPP's argument, the embattled MP at the time, argument was that the High Court lacked jurisdiction because of the late filing.
Yes.
That was the matter before the Supreme Court.
And that you relied on a different gazette.
So that even comes to light on the issue of institutional weakness. That's where I'm even going to. We should be able to, as of right, find out when was the election for Anglo or Keta or Temali gazetted. We should know. We don't have to struggle that this person will say, oh, this result was gazetted on this date. This person will say, it should be something simple.
Yeah.
So this the institutional weakness we have in this country.
But are you sure that was a case of institutional weakness? Because if you read the ruling of the court, they argue that matter has been settled in the Akwetia case.
That's what I'm saying. We've been in this country.
So if it's settled, didn't the NDC lawyers know about this before?
We've been in this country when even presidential result was amended 3 or 4 times. That's what I'm talking about. Presidential election after declaration in 2020 was amended 3 or 4 times. These are the cracks of the matter. Parliamentary election petition is governed by 2 major laws. The Constitution, Article 99, and then Section 18 of the PNDC law, I think 284, regulates it. Section 18 talks about the fact that you must file your petition within 21 days.
Yes.
You understand? Yeah. Anything short of that, the High Court will lack jurisdiction. Right. The MPP rightly invoked the supervisory jurisdiction of the Supreme Court, and the certiorari application was granted. If there's contrary evidence to show that the gazette the petition was filed within 21 days, then the review application will be tenable, will be justifiable. But if there's no contrary evidence, then there will be no need to go for a review, to be very honest. When it comes to the law...
So you feel there'll be a challenge there?
But because the issue is the 21 days, that's the issue. Yeah. For the substance, and that's why people are in pain. Yeah. People are really in pain because if we know that we voted and our person won, and just because of publication, gazetting, our vote is not being counted, you see that the NDC PC will have lost the case, not on substance, but on procedural matters. And that is what I'm talking about, institutional. I imagine this had happened, this was large scale. How would the country for that wrong people are representing them in parliament?
Am I getting the sense that you want to attack the Electoral Commission because of this?
Not attack. I'm talking about institutional weakness.
Yeah, but the institution responsible for elections in this country is the EC.
Yeah, and that is the Ghanaian way. Most of the institutions in this country are not living up to expectation. That is my worry. Because how on earth are we in this country? We cannot easily. If I ask you that where you vote, let's say you vote at Ayawaso West Wagon, and I ask you,
when was it gazetted?
You don't know.
Oh, why won't I tell you? It was gazetted in December, isn't it?
You see, there should be a system so that after election, you can just go online. Oh,
yes, and check.
Tamale was gazetted on this day.
Yeah.
Cape Coast
was done on this day, yes.
We don't have to struggle. Bantama was gazetted. We don't have to struggle. And that is my worry as a country. And when it comes to the issue of the law, I don't do politics. The facts are clear. The matter before the Supreme Court is not the election petition itself. It was the fact that the High Court lacked jurisdiction.
Now, don't you see a new twist? Just as I was asking Lawyer Darko there, that now they're saying, well, in terms of procedure, the NPP side also got it wrong because they should have gone to the...
No. They went to the Supreme Court to invoke the supervisory jurisdiction of the Supreme Court. If you are going to the Court of Appeal, you are going to appeal the substance, that's the election petition judgment. But this one, they are going to get the judgment quashed by a certiorari, and you can only get that at the appropriate forum, which is the Supreme Court.
The review is not going to work, basically. That's what you're saying.
I'm not on the bench. But unless there's a contrary evidence to show that the gazette was done within 21 days, otherwise, trust me, the review will fail.
Lawyer Danko, let me bring you up on that. We're just coming from a by-election, and then now you find lawyers on behalf of this candidate also doing the same. Are you down-spirited in Parliament, knowing that your numbers may further reduce? That is if the courts get to depart from their earlier ruling now.
Oh, no, not at all. Not at all. I mean, look, the application faces a very daunting task of even passing the first stage. That is whether there's an exceptional circumstances that must, give the Supreme Court the right to even review the matter and then go into the matter itself. Because before the review application itself is granted, you need to show that there's an exceptional circumstance. I've read the motion and the affidavit, and I don't see the exceptional circumstance that will even allow the court to assume jurisdiction and then grant the application. And so on this, I am very confident that the 4-1 majority decision will stand. We are not down-spirited at all. The NPP is a very strong party. If we have to challenge this, if it comes to it, we'll face them in court. And we are going to do it. Now that they filed this application, we're going to file our response and we'll do battle with them in the court. But we have no doubt that looking at the law and the facts and their application will prevail. But look, like I said, we will talk about the question of law and give the Supreme Court judges the opportunity or the right to give us the judgment. But I think that my friend Wanda has admitted that when it comes to the law, there's no politics. The law is very clear.
Yeah.
The NPP or the Indam was right when he invoked the supervisory jurisdiction of the court to challenge the assumption of jurisdiction by the High Court. You don't do that at the Court of Appeal. And I am surprised that lawyers will be doing this to themselves. And we should do better as lawyers, not to take any matter to court because maybe clients want them. We should be able to advise clients. And I believe that if the lawyer had advised the client and you even have taken this course, this is bound to fail. And look, there is no two ways about that. Look, when it comes to review, what the judge, the chief justice is going to add 2 more judges to this. All right. And so it's going to be seven judges, okay, seven judge panel. Now, what kind of argument are they going to make to sway these 4 judges who heard this same argument and dismissed it? Because this same argument, like I said, was canvassed by no less a person than the presiding judge at the time, the Honorable Judge Tuaman. He advanced this in court that the NDP should have come by way of appeal to the Court of Appeal under Article 99(2). This argument was canvassed. It has already been canvassed. And the judges all listened and said, no, this is not a determination of the suit itself. This is challenging the jurisdiction of the court. And that can only be done through invoking the supervisory jurisdiction of the Supreme Court. And so how is this decision going to change? Even if the two comes and they feel that they want to start with Puaman, Justice Puaman, it's still going to be 4-3. Because I don't see how the 4 judges are going to be swayed by this same argument that was made. It was this same argument that was made during the hearing, and nothing has changed. Okay, so I don't know what is going to bring the difference.
If that's the case, how do you respond to concerns that you won on technicality, but the substance of the matter still remains, and that this is also about justice, perhaps to those who queued to vote? We're not, and we haven't, as of now, heard from any of the judges regarding the substance of the matter, which has got to do with the election, except for Justice Tanko, I guess.
No, but unfortunately, that is how our court system works. You can win a case through technical knockout or the hearing of the actual matter or the determination of the actual matter, and it's a fair deal. When the lawyers make a mistake, such as they did, you cannot blame anybody, okay? And this one is not just technical matter. It is, in fact, a statute issue. The statute is very clear that if you want to challenge election petition, you do that within 21 days after the publication of the Gazette notification. You didn't do that. So how do you even bring a matter before the court? So this is not so much about technical point. It has much to do about the lawyers who were involved in this case, that they should have brought the matter sooner than they did. This is an act passed by Parliament, and it has to be respected. That is what we're talking about. It's not so much about technicality, but it's about the fact that they breached a very important statute, and that's where it ends. But we believe that even if this matter had been determined on its merit, we believe that we would have still won the case, because having read the judgment of the High Court, I was completely taken aback how a judge can come to that conclusion. And I was very confident that the Court of Appeal was going to overturn that decision. But we didn't get there because we also realized that the court didn't even have jurisdiction in the first place. So we went to that route, and the Supreme Court, by 4-1 decision, agreed with us. And there's nothing wrong with that. It is perfect, and it's a legal route that we took.
Lawyer Wonder, the point about the way forward now for your candidate, he feels aggrieved. He believes that he actually won the elections, except that he can't get any remedy now because of the timeline. How do we balance the two now? Because it's a big challenge.
So like I said, our candidate is not a victim of the weakness of Ghanaian institutions, specifically the EC. He's a victim because if the judgment of the High Court is anything to go by, that there were irregularities. But the only reason why the case has gone nowhere is because of technicalities, late filing. That's the only reason, not because of the votes. And that is the worry, that it will get to a time, if this situation becomes large scale, then we are going to have some MPs in Parliament, not because the people want them, but because of technicalities. That is my worry. After the review, I don't think it will stand the test of time. To be very honest, it won't go anywhere.
Many have described the decision of the High Court judge as very controversial. The fact that the number of constituencies in doubt, it's just a minute part of a bigger constituency. Were you not surprised about that earlier ruling too?
Oh no, but if you want us to go into the substance, if you say those police stations were minute, they have significant impact on the overall election. So if you call for a rerun, I mean, it's fair. It's balanced. It's fair. He didn't say then this candidate is the winner. He said go and do a rerun for people to choose who they actually want. I mean, so that's on the balance. It's much better than this situation that we have, that a person is being forced, that a person case is thrown away because of late filing, and individuals do not gazette their own results. That's another issue. The candidates do not gazette their own results. It's our institutions who are supposed to do certain works. And if this institution fails, people are being what? Punished for that. That is what is happening. The NDC candidate is being punished for a failure of an institution of state to work. And that is my worry. If this becomes large scale, and I repeat, because in the next 2 years, we are going to an election. So one thing somebody can do is just find a way of being declared winner. Once somebody even goes to court to get a judgment, just because the petition was filed supposedly late, you are fine. Is this how we want to rule that we are in a country that you cannot go? There's no mechanism to check easily the date by which results are declared and gazetted. Is that what we want as a nation? I think we have to sit about.
When it worked for you in Akwetia, you were silent as a political party.
No, I have been very consistent. I have said that once the laws is fairly applied, I have no issue about it. That's why I'm here saying that if we file for review, I don't think it will succeed, because nothing significant has changed. There's no evidence to show that the gazette was done within 21 days, pursuant to Section 18 of PNDC Law 284. There's no evidence, contrary evidence. So on the basis of this argument, the review application will not see the light of day. That's my point. If you talk about the case of Akwetia, what were the facts? Is it the case that the petition was filed within a particular period and the judges would otherwise? Is that the case?
Well, no, my point is about the double standard you're talking about in the Gazette, because at that time, everyone had known, or by then everyone knew that, of course, the actual date for the Gazette would have been December 24, isn't it? So the candidate in Kpandai should have been guided by that.
But each elections are gazetted, election results are gazetted differently. They are announced differently. They are declared on different days. We can do a roll call of all the MPs. Their results were announced and declared on different days. Some even went as late as when?
After the post that.
Exactly. No, some even a week, two. Yeah. They have to change the collation center, blah, 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 and all of that. I'm saying that going forward as a country, there should be a mechanism. But one thing that happens in this country, unfortunately, is that once elections are over, we forget all the challenges. In 2020, presidential election was amended about 3 times after declaration. But we are all quiet about it. We don't care. Nobody seems to care, because the elections are over, there's a president, and life seems to be okay. But if we are not careful, these things will keep continuing. Did you see what happened at Techiman South in 2020? It happened again in 2024. Will it happen again in 2028? So if we don't tackle the fundamental issues, we'll be back to the same issues. That is the point I'm making.
Right. And for you, Lawyer John Darko, how much of a responsibility should the Electoral Commission be taking now, knowing that there are some challenges with the Gazette system, is it?
Well, let me just make this point so that we are all guided.
Yeah.
The law is very clear that it doesn't matter when the Gazette notification is published. Whenever it is published, you have 21 days within which you file your petition if you so wish. Okay? So if it's filed, let's even say on the 6th of January or January 31st or even February, you still have 21 days after the publication within which you can file your petition.
Yes, but in this particular case, you have a situation where there's, they are confused, at least that's the argument of the NDC side, that there's 2, 24th and the 6th of January. You had all of those arguments too.
We cannot be confused, because we all know that there was 24th December Gazette notification.
Yeah, but Matthew Nyindam, even in the first instance, argued that it wasn't that of the 24th. So
exactly.
Yeah.
But you see, so that is what if you follow the Supreme Court said the fact that the two of you, were under a particular misapprehension doesn't change the fact and the law. Because in their decision in the Akwatia case, they had come to the conclusion that it was a 24th December notification, Gazette notification that was valid. And so even Nyindam was under a misapprehension to come to that conclusion that was since January. So you see, if I have a misunderstanding of a particular law, it doesn't change the position of the law. And that much was made clear during the hearing.
Yeah, but does that not point to the institutional weakness that Wanda is speaking to now? The fact that someone has got to be competent, at least, in being clear on the Gazette.
No, but so you see, there was that Gazette notification, except that somebody challenged it. Somebody challenged the validity of it, and of course, it is valid. That's all. So the Electoral Commission had done its job by gazetting almost 95 or 96% of the results by 24th December. It was only the few polling constituencies, maybe about 5 or 6 polling stations, which still had issues. Okay, all those which didn't have issues, by 24th December, they had all been published. They were all in the 24th December Gazette notification. And it is not the Electoral Commission's fault to determine which constituency will have issue or not. Okay, so for instance, the NDC was challenging Okaikwe Central. Yes. They were challenging Tema Central. Is that the EC's fault? It is not the EC's fault that the NDC seems to, or a political party seems to challenge the validity of a particular seat. And so for the Electoral Commission, if you want to challenge the validity, they cannot publish the Gazette notification. And so by the time the Electoral Commission published the 6th General Gazette notification, they were dealing with only those constituencies that had issues. And so a constituency like Kpandai, which by the time the Electoral Commission gazetted it on 24th December, it had no issue. It went ahead and gazetted it. And so the NDC, when they felt that they wanted to challenge that particular petition, should have done that within the 21 days after 24th December. That doesn't lie in the hands of the Electoral Commission. It is you. And you know the argument they made in court that they saw a publication in the media. Who does that? Nobody does that. So if you are a member, let's say, if you are involved in an election and you've seen that after the declaration you've been cheated or there is a problem, you want to go to court, go look for the Gazette notification. Who should do that job for you? It's not the Electoral Commission. Because the Electoral Commission has already published its notification. You are the one who should have gone to court. And look, if you read the NDC's this process, they are accusing the NPP of fraud because the NPP did not tell them that the Gazette notification is 24th. The NPP said to them that this particular one is 6th January and not 24th January. And so they followed the NPP and filed their petition on 25th January. Who does that? It is your case. You have come to a conclusion that there's something wrong with the declaration. Why do you rely on your opponent to determine when to file your petition? Do you understand? They raised all these issues in court, and the court didn't listen. The court said, look, it is not the responsibility of your opponent to do your case for you. You have to go out there, look at the law and the facts that will support your case. Don't rely on the weakness or the strength of your opponent's case. Do your own case. So the NDC, at the time they were filing the petition, did not have the Gazette notification of December 2024. They were only looking at the Gazette notification, which was reportedly sent to them by the NPP. Who does that? So it was their own, in my view, negligence that led them to this place. But even without invoking the supervisory jurisdiction of the court, we believe that judgment was so wrong that the Court of Appeal would have overturned it anyways. And so there's no problem here. I don't believe that the Electoral Commission did anything wrong. They published its result and gazetted it. If you have any issue, you have to ensure that you look at the Gazette notification and file your petition within 21 days. Nobody is going to do that for you.
Counsel, is it your argument that we let go of the legitimate concerns that emerged in terms of some infractions that happened during the elections in Kpandai? Because both parties agree. I'm sure you in the NPP also agree that some of the disputed areas had challenges.
Well, the fact is this. The horse has already left the stables. There's nothing to discuss because you cannot bring the petition because the 21 days has passed. The court did not have jurisdiction. So you see, in the eyes of the court, in the eyes of the Supreme Court, nothing happened. Basically, that's what it is. The court declared, they quashed the decision of the High Court, quashed even the petition itself and all the others. So in the eyes of the law, nothing has happened. So you go back to the status quo ante. But I believe that, in all fairness, we need to be more careful in our elections because I am worried. I am worried that people are losing faith in our democracy. Look at the turnout of the Ayawaso East by-election. Look at the turnout. It is so bad that as political actors, we need to be careful. We need to keep the faith of the people in our democracy. Because a turnout such as this, okay, it's a slap in the face of our democracy. And so I believe that we need to do better. Either review electoral processes or even the way we do our own politics. We need to do better. And for us as young men, this nation rests on our shoulders. Anything that would derail our democracy, I am against it. And if there is anything that can be done to improve our electoral process, anything that can be done to improve our democracy, I am all for it because what happened yesterday, in my view, was a slap in the face of democracy. It should never happen. That people are standing there, there's election, and they are telling you, we won't vote. And some of them went as far as saying that unless you give us money, we won't vote. It's a very dangerous thing, and we really, as political actors, need to be careful, not especially for the youth, not for the youth to lose faith in our democracy.
All right. Grateful for your time, Lawyer John Dako, for joining us. So, yeah, he then veered into the just-ended by-election. And you've won, but with a very disappointing margin, isn't it?
Oh, no. In terms of the margin...
In terms of outcome.
Yeah, the margin is...
more people to be out to vote for.
Oh, no, but that's normally by-elections in this country. I mean, we have the history of by-elections. By-elections, I mean, and also because it was a foregone conclusion. Everybody knew there was no way the NDC would have lost the Ayawaso East election. It's a safe seat. And also because of the performance of this government. We are...
Oh, really? There's an issue of performance in here?
I mean, we are performing, we are delivering on our promises. We promised that we are going to have less than 60 ministers. We've delivered. We talk about the National Apprentice Program. We've delivered. We talk about the Ejumara Program. We've delivered. The no stress-free policy. We've delivered. So everything is going very well. Look at the dollar. Look at how stable the economy is. We didn't promise that we will arrest the dollar.
But if you're truly doing all of this, how come a lot of people were not out on the streets jubilating and then voting for you much more in the constituency?
Please also take note that we're in the Ramadan fasting season. And that constituency is largely by person within the Islamic faith. You understand? So, I mean, and apart from, like I've just told you, by elections in this country, you don't get the same numbers and all of that, the enthusiasm, because there's no presidential ballot paper to be given to you. You're just going to do the one-sided parliamentary election. But we maintain the margin of victory. The vote His Excellency Baba Jamal got, in spite of the low turnout, is significantly more than the entire vote of Dr. Mahmoud Bawumia. Oh yes, Bawumia got about 8,000 in 2024.
Really?
Yes, I'm saying this for a fact. In spite of
Can fact check you on this?
No, please do that. Please do that. I'm putting my credibility on the line. Dr. Bawumia got about 8,000, a little over 8,000 in the general election. And in spite of the low turnout, Baba Jamal, Baba Jamal got over 10,000. So even with the low turnout...
You're arguing that Baba Jamal is more popular than the former vice president in the constituency?
I'm saying even with the low turnout. These are facts. These are facts. So if the MPP are saying, oh, low turnout, we are just quite watching them. Even with the low turnout, look at the magnitude of performance, the margin of victory. And bear in mind that this country has a history of low turnout for by-elections. Particularly so when this is a safe seat. There was no way.
On grounds of principle, we've heard the likes of Musa Danko say that your party perhaps should have allowed Baba Jamal to contest as an independent candidate, and then you readmit him if indeed the people of the constituency accept him back because of the claims you had made as a political party that there was significant vote buying during the by-election.
No, like you noticed, the NDC since 2015 have attempted some number of reforms. We have once introduced the biometric system of voting, where every card-bearing member within the party, within the constituency, will participate in the primary to elect the candidate. The essence of that reform was to cure some defect in the current delegate system. The current delegate system has that people support people, there's some perception of transport and all of that. Look, in the MPP just ended flag bearership race. We were told that as much as 700 Ghana cedis were given to delegates, and their delegate list album is over 200,000 delegates. So 700 times 200 will give you how much? Another candidate gave 500 cedis per delegate times 210,000.
What were your candidates doing? Some were giving as high as 3,000 Ghana cedis. In fact, some even bought motorbikes.
So I'm happy that some state citizens are at the Supreme Court. Dr. Nyahota Maklo, you are aware of this case. Yeah, the Supreme Court trying to seek the interpretation as when you talk about internal election, how should it be organized? It should go beyond the delegates so that each card-bearing member...
You feel genuinely that this delegate system is breeding lots of issues of corruption and vote buying, possibly?
Not necessarily, but the Ghanaian culture now, you heard the MP saying that yesterday, I didn't see, but that yesterday some people say they won't vote because they've not
giving offered money.
So this goes beyond politicians, the citizenry. We need to, the attitude, the culture, we need to look at it properly going forward. Because if we say that politicians are corrupt, politicians are not credible, then you, the voter, demands money before you vote, how different will you be from the politician? We need to look at this properly. But my view is that the NDC did very well. The Honorable Baba Jamal performed credibly well. Prior to the primaries, Baba Jamal has been supporting people in the constituency through educational support, educational fund. Could this be termed as trying to influence people ahead of a future election? Because he has been in that constituency for God knows when. He contested the last election, the last primary in 2023. He lost narrowly to the late MP, may he so rest in perfect peace. So basically, the NDC, we are trying to do reform so that the Ghanaian politics will be much more credible. If the MPP pretend as if nothing is happening, we've been in this country, Bantama primary, somebody distributed vehicles. Each delegate, one vehicle. One delegate, one vehicle. At Bantama, we've been in this country, we witnessed all of this. People were quiet and all of that. But we, just even by seeing egg and pepper, we set up a committee. People distributed vehicles.
Yes.
The MPP took no action. But we just, I think, television and some egg.
Are you? I mean,
no. I'm just telling you that the NDC.
You have your own general secretary.
The president record
your party raising concerns about such acts. He issued a statement. The constituency party issued a statement on that. And all you're telling us now is that, well, these are meager sums of money. You shouldn't care about it. The election is over. There's no need to probe the matters again. What will be made of the committee that's set up and possibly the sanctions? I don't know if you're able to sanction anyone now that the result is out.
Rather, the argument I'm making is that the NDC is a serious party, that we do not take little things. You can imagine what the NDC would have done if vehicles were distributed. Bantama, the MPP primaries, a particular candidate gave each delegate vehicle. Every delegate will have one vehicle to win a parliamentary election in Bantama. Yet
Have you seen the cast yourself?
Oh, I saw it. I saw it. Oh, you can do it. Oh, this is public knowledge. So if, for example, this television we're talking about, I didn't see it. I also saw it on social media.
But you saw the cast?
Oh, yes. Yeah. I saw it
but
on
you can't
social
see
media.
Television sets on social media.
No, I've admitted that things were distributed.
Yeah.
But the Ghanaian...
You're picking and choosing now because you want to favor your political parties.
No. We need to look at funding of political parties largely. I've just told you that the MPP flag bearership election had monies given out under the umbrella of transport. A particular candidate gave 700 Ghana cedis to people for transport. And some people were okay.
The NDC did same in your presidential primaries.
So you are doing equalization now?
No, it's not. It's a matter of reference.
So our last presidential primaries, President Mahama...
He distributed money to your delegates.
He was even open about it. He wrote that each delegate should give 40 cedi.
50 Ghana cedis.
It's 40 cedi.
Oh, it's not...
But it's okay.
Yeah, whatever the case. Okay.
It's okay.
So
Yes.
10 cedis. 50 Ghana cedis.
For transport.
Okay.
So
40 for transport,
exactly.
10 cedis for lunch, is it?
Sort of.
Which
cumulatively 50.
Yeah, 50 Ghana cedis.
So reasonably, if you give a delegate 40 cedi for transport, and I can tell you, a delegate who moved from Shime to Anglonga to vote spend more than 40 cedi for transport. I'm from the Anglo constituency. Right. If you want to, they take 2 vehicles from Shime to Anglonga, the voting center, to vote. You spend more than 40 cedi. As compared to a candidate giving 700 cedi for MPP delegates in Shime to Anglonga to vote. One can argue that those monies were intended to influence the delegates. But that is not why we are here.
Could it not
but the
be
point
out
I'm saying
of care? If your candidate also cared for NDC delegates, why wouldn't the NPP candidate care for the grassroots?
So like I said, we need to have a larger conversation.
You're both culpable of all of these things.
Exactly. So that is why we are talking. Let's have a national conversation.
You look as though the NDC is far better.
No, you have referred to our committee, and I'm telling you that it tells you that the NDC, we are looking at the interests of this country. Let's look at the national issue of funding of political parties. You know, there's a law that talks about even auditing political parties, submitting the accounts to the EC.
Which the 2 political parties rarely do, by the way.
So we need to have a larger conversation about this. Who transport voters? Let's have a conversation. Bipartisan approach. Who transport voters in this country? Will be the responsibility of the state, the EC, political parties, aspirants. Let's have a conversation. That's what is bringing all of this. Who gives lunch? Because if there's an election and I want to give lunch and I don't have money to give fried rice and I can cook egg, will that be an infringement? Let's have a conversation.
But practically speaking, as a politician, because you're not new to this business, are you telling me that we can practically, eliminate this? Even if at national level, by election, people are saying no money, no vote, how are you even going to eliminate that in your delegate system? So
that's the danger. So the NDC, probably, if we had kept to the reform in 2015 of maintaining the one party card member, one vote, probably would have improved that system. We reverted back to the delegate system because of the challenges associated with that system, where even some MPP members got our card and were voting, determining who should be our candidate.
Some MPP members.
But if you say anybody with NDC card can vote, anybody at all can just come and register and become and have a card and now decide who becomes the NDC candidate. So quickly we reverted back to because we lost the 2016 election. Quickly we reverted, as part of the Professor Butcher's report, we reverted back to the delegate system. I'm saying that if we had accepted that challenge, worked on that challenge with that system and continued with that system, probably by now that system will have been much better. But we abandoned it, went back to the delegate system, energized the grassroots, and we are back to power. But have we solved the issue? That is what we should be looking at as a country. Have the MPP fixed the issue of distribution of vehicles, giving huge sums of money for transport under the umbrella of transport? Let's have a conversation. I don't want us to look at it NDC, MPP. Let's have a conversation.
Okay. I believe that we'll do that conversation probably when we have another appropriate forum. We need to go. Okay, you're holding a book in your hand now because you're specializing in immigration law as well. Tell us about this.
Yes, so this is the first immigration law book in Ghana.
The very first?
Yes. When we were at law school, we bought a lot of books on contract law, criminal law, but there was no book on immigration law. I've been practicing on immigration for some time now. When I was in the US, I was an attorney in New York. So this is my field. So I wrote a book on immigration law titled The Immigration Formula, Rules, Packaging and Strategy. It was forwarded by Professor Larry A. DiMatteo, former editor-in-chief of the American Law Business Journal, Lordship Justice Emmanuel Yuni Kolendi, Justice of the Supreme Court of Ghana.
Oh, he was part of the panel on the Kpandai case.
That's not what we are talking about. We are talking about the immigration formula. So it will be launched next week, Friday, 13th of March, at the Ghana Shippers Authority. 13th of March. You might want to have a look.
Thank you. I'll take that. Yeah, I hope this is not both votes buying, by the way, because I'm not a delegate. The next time you're standing for election,
straight to the camera.
Obviously, I'm sure that this will not matter to the race.
Oh no, this is an immigration law book. It's for educative, academic, and it's both for lawyers and non-lawyers to navigate the complex world of immigration. You know, if you look at the topics, refugees, asylum application, grounds for visa refusal, revocation of visa. You know, Kedoforiata is discussed here.
Oh, you discussed it.
It's there.
I'm interested in that.
Yeah.
Oh, okay.
Is there?
I see. It's in there.
Revocation of visa. Is there.
So you believe you'll be back?
We have 37 exhibits. 37 exhibits in this book.
Powerful.
Yeah.
Powerful.
Yeah.
Powerful.
Yeah.
I wonder why Veritas is sent to you. But anyway,
No,
Council, thank you.
no.
Thank you for joining us. And of course, I'm sure that one of these days we should have a conversation on this and the technicalities revolving around that. Congratulations to you as well.
Thank you.
Wonder Victor Kuto, a member of the National Executive Committee of the National Democratic Congress, also board member of the VRA. Grateful to lawyer John Dako as well for joining us earlier. I am Blessed Sogah. Log on to myjoyonline.com. More stories there for you. That's it for UpFront. Next time you see us, we'll be on another matter. Thanks for watching. Bye for now.